So, a company's in deep financial trouble, and the legal side of things, it feels like this massive, tangled maze. But what if I told you there's a map? Well, that's exactly what we're going to do today. We're going to lay out a step-by-step guide to the legal authorities that handle corporate insolvency in India, from that very first filing all the way to the final appeal. Let's dive in.
All right, so here's the game plan. We'll kick things off at the ground level with the adjudicating authority. Then we're going to climb the appeals ladder to see how decisions get challenged, taking it all the way up to the Supreme Court. After that, we'll dig into the rules that are designed to keep this whole system efficient and on track. And finally, we'll wrap up with the really serious stuff, the penalties for anyone who tries to cheat the system.
Okay, so every single one of these corporate insolvency cases has to start somewhere, right? There's a single front door everyone has to go through. And that's where we're starting.
And that door is called the adjudicating authority. You can think of it as, mission control for all things insolvency. It's the one place with the power to make those first, absolutely critical calls. Now, for any company in India, any corporate person, as the law calls them, that authority is the National Company Law Tribunal. You'll hear it called the NCLT. So the key takeaway here is, if it's a company, its insolvency story always starts right at the NCLT's front door. No exceptions.
And let me tell you, the NCLT's power is, it's huge. It's incredibly broad. It's not just about the main insolvency application. We're talking everything, any proceeding, any claim by or against the company, even questions about who gets paid first or what the facts of the case are. And this is all by design, you know? The whole point is to keep everything under one roof. It stops the case from getting chopped up and sent to a bunch of different courts, which would be a total nightmare.
Okay, so the NCLT makes its call, but what if you're on the receiving end of that decision and you think, no way, they got this wrong? Well, that's where the next part of our map comes in. It's time to start climbing the ladder.
You know, it's a pretty basic question for any legal system, right? Is the first decision the last word? Well, in India's insolvency code, the answer is a big, resounding no. There is a very specific path you can take to challenge it. And that path leads you to the next rung on the ladder, the National Company Law Appellate Tribunal, or the NCLAT for short. This is basically the dedicated court of appeals for reviewing what the NCLT decides. The process itself is pretty simple on paper. So the NCLT hands down an order. Then, if you're someone who's been negatively affected by it, or aggrieved in legal terms, you file an appeal. From there, the NCLAT takes a look and makes its own decision. Simple, right? But, and this is a big but, you have to be fast. You have just 30 days. That's it. 30 days from the date of the NCLT's order to get your appeal filed. And this isn't just an arbitrary number. This tight deadline is there for a reason, to make sure these insolvency cases don't drag on forever.
Now, there is a tiny bit of wiggle room. The NCLA can give you an extra 15 days on top of that, but you have to have a really, really good reason for being late. You can't just miss the deadline and hope for the best. And here's another critical point. You can't just file an appeal because you don't like the outcome. That's not how it works. You need solid legal reasons. For instance, you have to prove that the approved rescue plan, the resolution plan, actually breaks the law. Or maybe the person in charge, the resolution professional, messed up in a major way. Or hey, maybe the plan didn't properly account for what's owed to operational creditors. You need one of these specific legal keys to even open the door to an appeal. All right, so we've gone from the NCLT up to the NCLAT. But guess what? The ladder goes even higher. There's one final stop, the absolute top of the legal food chain in India. That's right. You can take your case all the way to the Supreme Court of India. This is the highest court in the country. And whatever they decide, well, that's the final answer, period. Now, the clock is ticking here too, but they give you a little more time. You've got 45 days from the NCLAT's order to file your appeal with the Supreme Court. And yeah, just like with the NCLA, you might be able to get a 15-day extension, but again, only if you have a rock-solid reason for the delay. Okay, this next part is absolutely critical to understanding how this all works. Appeals to the Supreme Court can only be on a question of law. What does that mean? It means the Supreme Court isn't there to reinvestigate the facts. They're not going to ask, what happened? That's the job of the NCLT and NCLA. The Supreme Court's only job is to ask, was the law interpreted and applied correctly? It's a huge distinction, and it's what keeps the entire system from getting bogged down. So you've got this whole ladder structure, right? But for it to actually work, the system needs to be protected. It needs to be shielded from outside noise and internal delays. And the Insolvency Code has some really smart rules built right in to make sure that happens. Just listen to this. This is straight from Section 63 of the Code. It says, no civil court or authority shall have jurisdiction on any matter on which the NCLT or NCLAT has jurisdiction. What this does essentially is build a legal fortress around the insolvency process. It says to all the other regular civil courts, stay out. If it's an insolvency matter, only the NCLT and NCLAT can touch it. This is so important because it prevents chaos and conflicting decisions from different courts.
The code also has a built-in stopwatch, a way to hold the tribunals accountable for delays. So if an application isn't dealt with in the time it's supposed to be, the tribunal can't just let it slide. They have to put it in writing, on the record, exactly why it's delayed. And then the head honcho, the president or chairperson, can grant one final extension, and it's capped at just 10 days. It's a clear message. Keep things moving.
Okay, last but definitely not least. When you create a system this powerful, you have to protect it from people who want to abuse it. And believe me, the code comes with some very sharp teeth. It has serious penalties for anyone caught trying to play games or commit fraud.
Just take a look at the consequences here. They are no joke. If you start an insolvency case just to be malicious, you're looking at a penalty that can go up to 1 crore rupees. Ouch. But it gets even more serious. What if you're a director and you're caught running the business specifically to defraud creditors? Or you keep trading, knowing full well there's no hope of avoiding insolvency. In that case, the court can order you to personally pay up to contribute your own money to the company's assets. We're not just talking about fines anymore. This is about making sure the system is respected.
So there you have it. We've walked through the entire legal map. We started at the NCLT, climbed the ladder to the NCLAT, and went all the way up to the Supreme Court's final review. And we've seen how it's all protected by strict rules and some really harsh penalties. This all leads to one big, crucial question. When you have a clear, predictable, and protected legal system like this, what does that actually mean for the confidence of creditors and investors in India? Because at the end of the day, their trust is what this whole framework is built to support.